5 seconds to go. Start. The appellant's presence at the spot and the victim and the injured witnesses sustaining injury in course of the scuffle could be held to have been established from Exhibit 96 itself. However, by not looking into Exhibit 96 with the other evidence on record, what the trial court omitted to consider is whether the prosecution was justified in claiming that the offensive act amounted to culpable homicide amounting to murder, or whether the appellant being guilty of culpable homicide not amounting to murder deserved punishment under section 304 part 2nd IPC. True it is, the trial court considered the arguments advanced on behalf of the appellant that he had exercised his right of private defense, and though they exceeded such right, the present case at the most would fall under section 304 part 2nd IPC, but it proceeded to overrule such arguments by relying on the oral testimony of PWs 2 to 4. In the process, the trial court failed to appreciate the defense version as spelled out in Exhibit 96, which appears to us to be plausible. A senior citizen who visits Katol from Nagpur, his place of residence for collecting rent, having the intention of murder, would possibly not attempt to do so in broad daylight and in the presence of witnesses, and that too with a weapon such as a knife. Reading Exhibit 96 as it is, we do find it probable that there could have been provocation at the instance of the victim, who allegedly indulged in spitting on the appellant coupled with verbal abuse, whereafter PW2 and later PWs 3 and 4 sprang into action, resulting in a scuffle where both parties indulged in inflicting injuries on each other, resulting in an unwanted loss of life. Regrettably, pointed attention of the High Court does not appear to have been drawn to Exhibit 96 by counsel on behalf of the appellant, as a consequence whereof the court went on to hold that the act could not be shown to have come in any of the exceptions enumerated in section 300 of IPC, that it is neither the result of sudden provocation nor done in the heat of passion during quarrel, and that it had no hesitation to hold that the death of Nand Kishore is culpable homicide amounting to murder. Be that as it may, we have no difficulty in proceeding to record our conclusions resting on the evidence on record as well as Exhibit 96, which the appellant voluntarily filed before the trial court as his response to the incriminating materials appearing in the evidence against him while being questioned under section 313 CRPC for whatever it is worth. It appears to us to be a fair and proper disclosure of the appellant's version as to what transpired on that fateful evening. The offensive act committed by the appellant has to be appreciated in the surrounding circumstances noted below. In the normal run of events, the victim, as well as PW2 and the appellant were not supposed to interact with each other on 26 September 2013. PW2 opened the shop of the victim because the victim had not returned from the field. If PW2 had not opened the shop, the appellant would probably not have met him. It was by chance that the appellant and PW2 met each other. The victim and the appellant had no quarrel with each other. Whatever was there, it was between the appellant and PW2. The inter se quarrel between the two had long subsided. There is a missing link in the prosecution case as to the motive of the appellant to inflict the blow on PW2 first. Stop.